You can jaywalk here, split lanes on a motorcycle, sell jam you made in your kitchen, and buy a tamale from a cart on the sidewalk. In some states, those things will get you a fine. In others, an arrest. Welcome to California. If we haven't met yet, I'm Christine Donovan, 4th generation in real estate, 3rd generation in coastal Orange County, attorney and broker. I've lived here for over 30 years, raised my family in Costa Mesa, and grew up right here in Newport Beach. And I still find things about this state that surprise me. So if you're thinking about relocating to California, this one is for you. Before we get into it, which one of these surprises you the most? Drop it for me in the comments. I'm genuinely curious what people don't know going in. Today, I'm going to talk about 10 things that are legal in California that may not be legal in other states. And one of these you've never heard of. If you've ever felt trapped in a job because of a contract you signed, you're going to want to stick around for number 10. California has always done things a little differently. Sometimes that means leading the country in something important. Sometimes it means you can cross the street wherever you want. Either way, if you're moving here from another state, there are things that are completely normal here that would have gotten you a ticket or worse back home. Let's go through them. Number 1, jaywalking. As of January 2023, California decriminalized jaywalking. It's called the Freedom to Walk Act. You can legally cross mid-block as long as it's safe to do so. Police can only stop you if a reasonably careful person would see an immediate danger of collision. Now, I'll tell you why this one's personal. My kid was visiting Alaska not too long ago, stepped off a curb to cross the street. No traffic anywhere in sight. A man in uniform stopped him and yelled at him for jaywalking. My kid grew up in Costa Mesa. That had never happened to him once, because here, crossing the street when it's safe is just crossing the street. Most states still ticket this. Some enforce it harder than others. Alaska apparently takes it seriously. Here, it's just another Tuesday. Number 2, lane splitting on a motorcycle. If you ride, you already know this one. California is the only state where full lane splitting is legal, meaning riding between lanes of traffic that's actually moving. A handful of states have recently passed lane filtering laws, which let riders pass between stopped or nearly stopped traffic. That's a more restricted version. Here, you can split moving lanes, even if I don't appreciate the fact that my brother likes to take advantage of this one. Most states don't allow either. Number 3, recreational marijuana. California legalized it in 2016. We were one of the first. A lot of states have followed since, but there are still plenty where this gets you arrested. Here it's taxed, regulated, sold at licensed dispensaries statewide. Number 4, growing cannabis at home. This one surprises people. In California, adults 21 and over can legally grow up to 6 plants per household. No commercial license, no special permit, just your home. And indoor growing is protected at the state level, meaning local cities cannot take that right away. In many states, that's still a criminal offense, meaning you could be arrested for the same thing that's completely legal here, at least under state law. Number 5, selling food made in your own home kitchen. California's Cottage Food Law lets you make some food at home and sell it. Baked goods, jams, granola, candies, dried pasta, farmers markets online from your front door. No commercial kitchen required. Now here's what that actually means in real life. There are people in this state who've been perfecting a recipe for 20 years. A recipe passed down from grandma, a jam that everyone at the neighborhood block party always asks about, a sourdough that people have been begging to buy. In lots of states, that hobby stays a hobby, because to sell food legally, you need a licensed commercial kitchen, which means rent, equipment, permits, overhead. Most people never make that leap. Here, you don't have to. You register with your county health department. You label your product correctly, and you're in business. The state's own Department of Public Health runs the program. California's version is considered one of the most permissive in the country, and that's not an accident. California has always understood that small food businesses start at someone's kitchen table, and the law here actually reflects that. Number 6, buying from a street vendor. This is one I want to take a moment on because it's not just a law, it's a statement about what kind of place California is. Growing up in Newport Beach, street vendors weren't part of the daily landscape, but over time that culture has moved closer to the coast. And today you'll find tamale carts and elote vendors in neighborhoods where you never would have seen them 30 years ago. And here's the thing, they're protected. In 2019, California passed the Safe Sidewalk Vending Act, which decriminalized street vending statewide. Cities cannot ban vendors outright, cannot hit them with criminal charges, can only issue administrative fines and only for specific health or safety violations. That tamale cart, the fruit stand, that elote vendor on the corner, protected. And what that means for someone relocating here is that the street culture you're going to experience in coastal Orange County, the one that makes this place feel alive, isn't happening in spite of the law. It's happening because of it. Number 7, building a second home in your backyard. I see this one as something that changes people's lives. California has made it dramatically easier to build a second unit on your property, a backyard cottage, a garage conversion, a junior ADU inside the home. And state law overrides local restrictions, meaning cities can't simply say no. Now, most people hear ADU and think rental income. And yes, that's real. In coastal Orange County, a well-positioned ADU can generate $2,500, $3,500 a month or more on property you already own. But that's not the story I want to tell right now. The story I want to tell is about why someone buys a specific home. I know someone who was relocating to the area and was very intentional about what she was looking for. Not just bedrooms, not just schools, not just commute. She wanted a backyard configured for a second structure because her parents were getting older and she wanted them close by. Not in the same house, but close. Close enough to help with the kids in the morning, close enough to have dinner together without it being a production, close enough to be family without being on top of each other. She found the right property, built the ADU, and now her parents are 20 feet away. Her kids truly know their grandparents, see them on a daily basis. And she has the help she couldn't have afforded another way. That's what this law makes possible, not just income, not just density, a way to keep families together on a single piece of property in one of the most expensive housing markets in the country. Most states can't offer that. Here, it's written into law. Number 8, displaying any non-commercial sign in an HOA. Political signs, pride flags, religious banners. In California, your HOA cannot ban them. It's written directly into state law. The Davis-Stirling Act, Civil Code Section 4710. They can regulate size. They cannot regulate your message. In a lot of states, HOAs have broad power to restrict all of it. Here, your property, your voice. Number 9, happy hour. I saved this one for exactly this moment because we need a little fun stuff after all that serious stuff. Happy hour is completely legal in California. Discounted drinks, 2-for-1 specials, half-price appetizers, the whole thing. In at least 7 states, it's illegal. Alaska banned it in 1985, officially because it encourages overconsumption. Now, I mentioned earlier that my kid got yelled at in Alaska for jaywalking. So let me just say this. In Alaska, you can't jaywalk and you can't have happy hour. No judgment, but also welcome to California. Number 10, your non-compete agreement. Here it is, the one I promised you. If you've ever taken a job and signed a non-compete agreement, you know what it feels like to be handcuffed. Can't work for a competitor, can't start a business in the same industry, can't use the skills you've spent years building without risking a lawsuit. In most states, that agreement follows you. In California, it doesn't. Non-compete agreements in the employment context are void under California law, not just discouraged, not just hard to enforce, void. Under California Business and Professions Code Section 16600, any contract that restrains someone from engaging in a lawful profession, trade, or business is unenforceable. And here's the part that stops people cold. As of 2024, that protection applies even if you sign the agreement in another state. You move to California, you work in California, your employer's non-compete does not follow you here now. There are exceptions. They're narrow, and they mostly involve the sale of a business, not standard employment situations. For the vast majority of people relocating here for a job, the non-compete you signed is not enforceable. And in fact, California now requires employers to notify employees that their non-compete agreements are void. Think about that. The state requires your employer to tell you that you're free. If you're sitting somewhere right now feeling stuck in a job because of a piece of paper you signed and you're thinking about moving to California, that piece of paper has a lot less power here than your employee wants you to think. Attorney brain genuinely cannot turn it off, and honestly, I wouldn't want to. And because that's true, I also want to remind you that I am not an employment labor attorney, and I am not providing legal advice. Check with your attorney before you make any changes. Here's what I want you to take from all of this. California has a completely different legal and financial landscape than almost anywhere else in the country. Different protections, different opportunities, different rules. And most people who relocate here don't realize that until after they've already bought. By then, some of those decisions can't be undone. The ADU you could have built but didn't know about when you were looking at lots, the structure of a deal that looked fine on paper but had language in it that an attorney would have caught, that's not a hypothetical. That's what I see. The property is the rose, but the foundation is understanding what you're stepping into before you step into it. And California's foundation is unlike anywhere else. That's why I do what I do. I work with people who are relocating to coastal Orange County and who want more than an agent who can open doors. They want someone who can tell them what those doors lead to. Not just the price, not just the payment, the full picture. What you can build, what you can protect, what you can create before you commit. Because in California, the decisions you make going in are the ones that matter the most. Clarity first, then strategy. So, which one surprised you the most? Drop it in the comments. I read every one. And if you're relocating to California, thinking about moving to California, Orange County, Costa Mesa, or even out of state, book a call. I can help. I have a strong network of agents locally and nationwide. No pressure, just strategy. I'm Christine Donovan, broker, attorney. Clarity first, strategy that sells. And we'll see you in the next one.